There's a major development unfolding around the legal battle over suppressors and their status under the Second Amendment. A previous ruling by a three-judge panel in the Fifth Circuit found that suppressors are not considered arms and therefore are not protected under the Second Amendment. But now that decision is back under review and the dynamics of the case have shifted significantly. What's especially notable is the recent change in position by the Trump-era Department of Justice. Under Attorney General Bondi, they've now filed a brief supporting the argument that suppressors are in fact protected arms. They've stated clearly that an outright ban on suppressors, whether by state or federal authorities, would be unconstitutional. This new stance is adding serious momentum behind the push for the full Fifth Circuit en banc panel to take up the case and potentially overturn the previous decision. This could be a major step toward challenging and possibly dismantling parts of the National Firearms Act, NFA, particularly as it relates to suppressors. The plaintiffs in this case, Mr. Peterson and the Firearms Policy Coalition, FPC, are now urging the Fifth Circuit to grant an en banc review, revisit the flawed reasoning of the prior decision, and recognize suppressors as constitutionally protected. Let's break down the case in more detail. The case at the center of all this is United States versus Peterson. Mr. Peterson was convicted of violating the NFA for possessing a suppressor, specifically a solvent trap, that was not registered. His legal team argued that the NFA's suppressor restrictions infringe on his Second Amendment rights. However, when the case reached the Fifth Circuit's three-judge panel, the court ruled that suppressors don't qualify as arms and thus fall outside Second Amendment protection. That's where things stood, until the DOJ's recent filing changed the landscape. In their brief to the en banc panel, the DOJ stated that while they believe the NFA restrictions don't constitute an outright ban, they do agree that suppressors are arms. As such, the previous court ruling needs to be reconsidered. They've essentially called on the full panel to reverse the earlier decision and reject the flawed conclusion that suppressors are not protected under the Constitution. This shift from the DOJ is a major development, and Mr. Peterson's legal team is now leaning into this position change as they request the full Fifth Circuit to take up the case and strike down the suppressor-related restrictions in the NFA. Let's take a closer look at how the Fifth Circuit initially ruled in this case. When Mr. Peterson challenged the suppressor-related charge under the Second Amendment, a three-judge panel in the Fifth Circuit sided with the ATF and the DOJ. They determined that the motion to dismiss had been properly denied and that the Second Amendment does not extend protection to suppressors. The court concluded that suppressors are not arms as defined by the Constitution. In their opinion, the Fifth Circuit noted that this was a matter of first impression within their jurisdiction, that is, they hadn't ruled on this specific issue before. They also pointed out that, in their view, every other court that had looked at the issue had ruled similarly, rejecting the idea that suppressors are constitutionally protected. The panel analyzed whether suppressors qualify as a weapon used offensively or defensively, or if they could be classified as a tool used to project or strike at an opponent. They concluded they do not meet that criteria. The court acknowledged that Peterson argued suppressors are an integral part of a firearm, and therefore should fall under Second Amendment protections. But the court rejected that position. They wrote that a suppressor by itself is not a weapon. Without being attached to a firearm, it serves little purpose in terms of self-defense. In their reasoning, unless someone were to throw a suppressor as a projectile, it cannot perform the action of casting or striking. The court also found that suppressors are not essential to the operation of a firearm, nor are they necessary to make a firearm functional or effective. Because of this, the panel upheld the original ruling from the lower court. That decision has understandably raised concerns, especially since it could set a precedent suggesting that firearm accessories and components like suppressors do not fall under constitutional protection. In response to this ruling, Mr. Peterson and his current legal team at the Firearms Policy Coalition have filed a request for the full Fifth Circuit, sitting en banc, to review the case and overturn the panel's analysis. Now here's where things get even more interesting. Following the shift from the Biden administration to the Trump administration, there were still attorneys within the DOJ who initially continued supporting the panel's decision. They argued that a rehearing wasn't necessary and that suppressors were not protected under the Second Amendment. However, that position has now dramatically changed. Under the Trump administration, the DOJ submitted a new brief indicating a full reversal in their stance. The government now acknowledges that suppressors are protected arms. They state that banning suppressors outright, whether by states or the federal government, would be unconstitutional. In this new filing, the DOJ explained that, under directives from the Trump administration, it conducted a broader review of its positions on Second Amendment litigation. As a result, the United States now recognizes that the Second Amendment does protect firearm components and accessories, including suppressors. According to their updated interpretation, any restrictions placed on the possession of suppressors infringe on the right to keep and bear arms. Therefore, a complete ban on these accessories would be unconstitutional. However, the DOJ also maintains that the National Firearms Act's requirements, such as registration and taxation, are still valid. They argue that those regulations impose only a modest burden and are consistent with historical legal traditions, particularly because suppressors can be adapted for criminal misuse. For that reason, they believe the court was still right to uphold Peterson's conviction, despite the updated view on constitutional protections. To summarize, the DOJ now believes that while a complete ban would violate the Constitution, the NFA's registration and tax requirements are acceptable under the Second Amendment. They've suggested that even if a full en banc review isn't granted, the panel's opinion should at least be corrected to reflect this updated legal perspective. Let's talk about what this means strategically and where things currently stand. The Department of Justice's new brief may be part of a broader effort to encourage the full Fifth Circuit, sitting en banc, to take up this case. If the en banc panel were to find that suppressors are indeed protected under the Second Amendment, it would create a significant split among the circuit courts. That, in turn, could open the door for the Supreme Court to weigh in. And during that review process, there's a possibility that the en banc panel could go even further, potentially finding that the National Firearms Act itself violates the Second Amendment. Notably, such a finding wouldn't even require the DOJ to directly argue against the NFA. Following the DOJ's shift in position, Mr. Peterson and his legal team at the Firearms Policy Coalition responded. They pointed out that the DOJ's new brief actually supports their request for an en banc hearing. The original panel ruled that restrictions on suppressors do not implicate the Second Amendment's protections, but now the government disagrees with that reasoning. That contradiction gives the full court a chance to correct the earlier ruling and align its interpretation with a more accurate reading of the Constitution on this important issue. The DOJ also suggested that the panel could revise its decision without needing a full en banc review by simply following the government's new position and recognizing that suppressors are protected. But as Peterson's team notes, the DOJ hasn't explained why the panel would suddenly reverse itself just because the government's view has changed. While they would welcome such a move, the importance of the issue calls for a more formal and comprehensive review by the full court. Additionally, while the government now acknowledges that the NFA's registration and tax requirements implicate the Second Amendment, it still argues that those rules are valid because they align with historical firearms regulations. But whether these requirements are consistent with constitutional protections is a separate, critical question, one that also deserves the full court's attention. So here's where things stand. Both the DOJ and Peterson's legal team are now asking for a review of the panel's decision. Both sides argue that the analysis used by the original three-judge panel was flawed and needs to be corrected. If the en banc panel agrees to take up the case, there's a real chance that we'll see a major ruling on whether suppressors fall under the protection of the Second Amendment. And that could have far-reaching implications. Even if the Fifth Circuit decides not to rehear the case en banc, this case could still move forward to the Supreme Court. What makes this so unusual is that both the defendant and the federal government would be asking the Supreme Court to review and reverse the lower court's ruling. That kind of alignment is rare, and it signals how significant this issue has become. Only time will tell how this case unfolds. But right now, one thing is clear. Both sides are urging the court to re-examine the question of whether suppressors are protected arms. This development also highlights the growing influence of the Trump administration's Second Amendment task force and how it's beginning to shift legal arguments in key firearms cases across the country. We'll be watching this one closely. If the Fifth Circuit en banc panel steps in, or if the case moves on to the Supreme Court, it could shape the future of how firearms and accessories are regulated in the United States. As this case develops, I'll continue to keep you updated. Thanks again for watching. If you found this video informative, be sure to like, share your thoughts in the comments, and subscribe to the channel for more updates on important Second Amendment cases.